Well, welcome everybody to our event here about in terms of communications, the upcoming Biden administration. As you know, this is a typically roughly monthly event that we do to talk about various cutting edge issues. Delighted to have anyone who's been with us before with us again today. And for the newcomers, welcome, and hope we find that you'll find that your time spent with us to be interesting. So we are delighted to have with us today a person who's a veteran of many of these things and a good friend of mine and a wonderful friend to CTIC, which is Kevin Werbach. Kevin Werbach is a professor of legal studies at the Wharton School, and more importantly, was the author of a seminal study called Digital Tornado, while he was a member of that was then called the Office of Plans and Policy at the Federal Communications Commission, who was in charge of thinking about what was going to happen in the future. And he was amazingly prescient in what he wrote. And in fact, it's led him to a distinguished career as an academic and in other directions as well. So we are delighted to have his perspective, because trying to figure out what's happening in the future is exactly the topic of today's subject matter. So we're delighted to have you here. And we want to make a couple announcements to make sure everyone's on board, just to be aware that we are recording this event, and to make sure that anyone that, if that's a concern, you should be aware that's happening. I want to remind people that there are some upcoming events. The Penn Intellectual Property Group and the CTIC is co-sponsoring an event this Thursday on the American Invents Act, Mission Accomplished Will Promise Unfulfilled, on the anniversary. That will be Thursday, March 25th at 3 p.m. And on April 6th, we'll have a similar event on the future of copyright law, looking at the CASE Act and beyond. There's a biography of Professor Werbach available in the program, which we welcome to you. But most importantly, among the many things he's done, he has, in addition to be a distinguished member of the staff of the FCC, he served as one of the leads for the Obama administration's transition team for the Federal Communications Commission, has helped develop U.S. government's internet and e-commerce policies throughout at different points, has been founded Supernova Group, a technology consulting firm, author of many wonderful, wonderful books on blockchain and other issues. And we are delighted to have his expertise joining us today. So just to start off, Kevin, why don't we just ask you, since we're trying to figure out what does the future hold in the space, what are the issues that you think that are on the top of your mind that you're keeping an eye on?
Yeah, so first, thank you, Christopher and CTIC. It's always a pleasure to have the opportunity to chat with you and to be involved in programs of the center. So a lot of the issues are obvious that they're going to be big issues, although the outcome is not entirely clear. If we're talking about communications policy, very clearly the Trump FCC under Ajit Pai made some significant changes in terms of, say, rolling back net neutrality and the classification of broadband, which was a significant policy initiative of the Obama administration. And so we clearly are going to see an effort at the FCC and potentially in Congress to reinstate net neutrality. We clearly, coming out of the pandemic, are seeing a lot of focus on broadband connectivity and expanding that beyond just the traditional focus on rural areas to underserved areas, to cities, and to really focusing in on getting better data and trying to have ubiquitous broadband. There's broadband funding in the Rescue Act, the stimulus bill, and there's talk about a lot more in the potentially multi-trillion-dollar infrastructure legislation that is likely coming very soon. So all these things are obvious to everyone that they are going to be top of mind for an FCC, at least under the Biden administration. And then other issues that are clearly high on the agenda. One is privacy, where I think it is quite likely, despite the difficulty of getting bipartisan agreement or even Congress to act without bipartisan support, there's such an impetus for doing something with regard to privacy, having actual comprehensive legislation in the U.S. The areas of disagreement between the different sides are really not that great. So I think that's something that Congress will move on, that also has an FCC piece, because in the Trump administration, Congress rolled back the Obama FCC's attempt to impose privacy restrictions under Title II on the internet service providers. Related to the privacy issue is the broader set of questions about regulating big tech, where again, there's bipartisan agreement that something needs to be done, but there I think a lot less clarity on what that is, and real disagreements. Do we need to break up big tech as the progressive wing of the Democratic Party would like? And it seems like with the appointment of someone who we both know very well, Tim Wu, Columbia Law School professor, to a position in the White House dealing with tech policy, and the nomination just announced of Lina Khan, also Columbia Law School, and a very strong advocate of strong antitrust action against big tech, being nominated to the Federal Trade Commission. Those are clearly going to be high-profile issues. And that's just a starting point. I think related to that, we have the issue of Section 230 about intermediary liability. And then, I'm focused, mostly though on kind of the broader issues. The international questions are really important, between the U.S. and Europe, and between the U.S. and China. I think those are going to be, and among all of those countries, as well as other major world powers, I think those are really going to be a very big piece of this puzzle in the coming years.
Well, you've set up quite an agenda for us to talk about, Kevin. We'll see if we can get how many of these we'll actually get through, but taking the first one first. So I'm actually curious to ask you something that you said, which is you're talking about different things about policies that will be different under the current administration than were true under the chairmanship of Ajit Pai. Well, it makes me want to ask a question. What kind of grade would you give Ajit Pai? Is he an F? I mean, were there some good but the bad, or what's your general sense of how the last FCC went?
Yeah, so, I disagree strongly with Ajit on most major policy issues, but I respect that Ajit is someone who thinks and understands tech and communication, thinks about and understands tech and communication policy. He's someone who his views are motivated by what he believes is the right set of answers for the country. Not just scoring political points. And he's someone who actually, I believe, cares about the institutional health of the FCC as an agency, which is not always true, of everyone that that is in a senior policy role in government. So I respect him for that. So maybe I'll give him a C in that. I think the FCC made a lot of mistakes in what it did and what it didn't do over the past 4 years, but compared to many of the senior officials in the Trump administration who were either incompetent or corrupt or really focused on politicizing rather than really trying to get to the right answer, I think Ajit was not in that camp. So I wouldn't endorse everything that he did. But a lot of what he did was going to happen under any Republican administration, given the way the politics lined up. It's
one of those things that's, whenever I see the party change hands, it's like if you can, like for the current administration, if someone opposes, if you can forgive the fact that they're actually a Democrat, and that's inevitable because elections have consequences, that's actually, I think, high praise for someone who basically is supporting the other party and understanding that he did things that were good for the institution. So just to throw some things out there from my standpoint, he greatly increased the transparency of FCC decision making. As you know, as well as I do, one of the weird things about the FCC is they would have every month, the full commission would meet to formally adopt things, and they actually wouldn't disclose what they were voting on to the public beforehand. And even after they vote, they wouldn't tell people. And you would think as a matter of good government, the public would have a right to know what was going on. And they would often rewrite orders after they voted on them and all these other really funny things. And Ajit Pai, to his credit, said, look, we shouldn't do that. I know that maximizes our flexibility, but we should disclose what we're doing in advance. It's just a good government thing for which I think Ajit Pai deserves credit. There were a lot of matters hanging around the FCC that had been around for literally, without exaggeration, decades. And he said, let's do something. If we have an action to bring, let's bring it. If we don't, let's wrap it up. And I think that that's also signs of good government. And so there are a lot of things I think about the Pai administration that have very little to do with the politics of the left and right, and everything to do with thinking that, if someone has a petition for rulemaking or an action by the FCC, at some point, the agency has an obligation to either act upon it or close it instead of just letting it sitting around for years and years and years. Something else that, I've been tracking on, I think more so than you, but that he did, which is, I think, he was part of, a long-standing bipartisan effort that spanned a number of years, is to address one of the first issues you talked about, which is universal service reform. And so one of the things that we've seen is under the pandemic is the need for broadband has never been more apparent, and the number of people who don't have it is not inconsequential in this country, and it's been a huge issue. But we've known for a long time that this was a regime created to give money, generally about $2.4 billion a year, traditionally to traditional wireline voice, traditional telephone lines. And anyone sitting here in the year 2021 says, you know, most of our students don't even have those anymore. And so there has been a bunch of very obvious reforms that have been very much needed. Shift from, if you're going to do voice for rural, instead of doing it by laying lines, which are very expensive, start to do it through wireless, because that's how most people are getting voice now. And shift the emphasis from voice to broadband, because you get a broadband connection. It can be voice when you want it to be. It can be a Zoom call when you want it to be. It can be anything you want it to be. And I think that one of the nice things that he has done, that the FCC accomplished, was to become part of implementing a revamp of universal service that dated back to the Obama administration. And it's funny, they actually ran a series of auctions. In the first couple they did, frankly, didn't work out very well. I mean, they were trying to get people to take federal money to connect more people to the internet. And in 2018, they tried to get people to take 20 billion, and only people only took 1.5 billion. And so the most recent version of this actually was very successful, connected about 5.2 million of the around 6 million homes they were trying to get to. And they've actually made a lot of progress in terms of making that better. New technologies, traditional providers who's traditionally sat out these kinds of auctions are now getting more involved. And we're solving what we know to be an enormous problem, which is getting more people online. And so that's an area where I think there is a bipartisan, as you mentioned before, commitment to bring more people online and to close what we often call the digital divide. And so hopefully, even in an area of very polarized politics, there remain issues like this where Democrats and Republicans can find common ground to the benefit of the American people, because we all need to get people online.
Yeah, and part of what's interesting is are the dynamics between the FCC, Congress, and the White House. That Chairman Pai, frankly, had a fair amount of running room because there weren't people in the Trump White House who had a lot of expertise or cared a great deal about technology policy. What happened in the Trump administration, where there was a conflict, it was on spectrum policy, which affected the FCC to some extent, but in particular NTIA and the Commerce Department. The director, David Rettel, basically resigned, because he was so in the crosshairs of this fight back and forth between different parts of the administration and the Pentagon and so forth. But on most of these issues, I think Ajit had running room and took it. There's value in both ways, though. I think there's value in tech policy and communications policy not being something that the White House or Congress is fixated on. But that's a problem too, because there's some things that require either support from those entities or coordination across the government. And what's interesting about the Biden administration is it's really quite different in a way from the Obama administration and the Clinton administration, which I was most involved in, or in what would have been a Hillary Clinton administration in 2016, and that tech and telecom are just not that central. They are, people have views on the issues, but you just look at the level of importance and what's at the top of the list for the people in the White House. And understandably, it's COVID vaccine rollout, it's climate change, it's China strategy. It's all things that make sense about why that's important. And they're very fixated on making sure they don't get too diffuse and focus on getting those things right. But sort of strangely, I think it's a time for the first time in a while where the Democrats are in power, but these issues are relatively speaking something of an afterthought, and it'll be interesting to see what that means.
Well, I couldn't agree more. I remember when the Trump administration came in, he's the first presidential candidate in quite some time that didn't have a technology policy as a matter of his campaign. And you could look for it, just didn't exist. And when you look for the Biden administration, you see little bits of it in terms of closing the digital divide, but to its undying credit, the Biden administration is laser-like focused on its main priorities. COVID relief, economy, racial equity, climate, immigration, and healthcare. And if it's not one of those 6 things, you're not going to get White House level support, which is the good news is that it's not going to be interference. But as you point out, the bad news is if there's something where you need to knit together some broader coalition, unless you can tie it to one of those 6 primary priorities from the administration, it's not likely to go very far.
Right. Yep. And so we don't have a permanent FCC chair nominee. We don't have a nominee for the 5th FCC commissioner. And from talking to some of the folks that are in the mix for those roles, that does not seem to be a high priority to happen very soon. In fact, most of the independent agencies, except for some of the financial regulators, there haven't been nominations yet. And so again, it's understandable why it's happening. And Jessica Rosenworcel, who's there as the acting chair, is very good and very experienced and knows what she's doing. But there will be a cost in these areas, even if one can say from 50,000 feet, it makes sense that it's not the priority. But things will not happen because it's not getting as much White House focus.
Well, speaking of trying to make things a priority, another thing that you mentioned was federal privacy regulation, or frankly, probably federal privacy legislation. I mean, because it's what we think about. In a world, well, when I went through my list, privacy didn't seem to fit close to the top of that. Yet you see a lot of interest right now in federal privacy legislation, a lot of hope, a lot of people think something's going to happen. Do you think it's going to be able to crack through this the priority list and to see something real, particularly in a world where the Senate split 50-50?
Yeah, oh, absolutely. It's because everyone cares about privacy. It's not a left-right issue. People care a lot about privacy. Now, of course, there are political disagreements about what the right thing to do is. But for a long time, there's been widespread agreement on the Hill, and it's something that ties into so many other issues. It ties into questions of COVID response. It ties into people's concern about the power of big tech platforms like Facebook and Amazon and so forth. And to the extent that there's a desire to get something done, it's so obvious that when you look at the framework that Europe has had for a long time with GDPR, not that is perfect by any means, but the fact that we don't really have anything comparable in the US, it just has become, I think, untenable. And industry is on board too. All the major companies believe they want clarity. They don't necessarily want too intense regulation, but they can see what's happening where states like California are getting further out in terms of what they're requiring at the state level. And so, I do think that will crack. I don't know what the analogy is, but that will get over the line. It's not going to be the first thing Congress does, first big thing Congress does. But that's the one that I'm relatively confident about.
Well, what's interesting is you mentioned California. You say that we don't have baseline regulation, but if you're going to do business in the U.S. with California residents, essentially you got to come to deal with that. But we're also seeing Virginia just recently passed a privacy statute largely modeled from California, but borrowing some from GDPR that was, 3 weeks ago, just fairly recently. You see a lot of proposals in other states, and you see these different things coming along. Trying to figure out what a federal government's going to do when it steps in. So because first is, I think there is some concern in many parts of the industry about facing 50 states, different rules, different rules in 50 states. I don't want to make too much of that. We do that right now with breach notification. We do it with torts and somehow we still sell products that survive product liability. But I hear sometimes when people say what they really don't want to have to do is to lobby 50 state houses around the country to work on the rules and, because that's just overhead. And if the rules really aren't that different across the country, maybe we're better off with one uniform set of rules. But the interesting question I hear also talked about is, in fact, though, you could see federal legislation that's as strict as California, but in many places I hear from the Hill, California is sort of the baseline floor. You could actually go tighter than California, but the California congressional delegation would be very resistant to the idea of watering it down any farther below what California is doing. Do you have any sense? Are they tied that way? Or what do you think? How much room is there for Congress to maneuver in this space?
Yeah, no, it's a good question. So the two sticking points for a while on the Hill on privacy have been preemption, first of all, which you talked about, and the other is private right of action, which is from some perspectives sort of the nuclear option. I mean, you look at the impact that just this obscure Illinois biometric privacy law that was passed in 2008 has had, because it has a private right of action and allows for class actions. Facebook has had to basically totally change its business and settle for hundreds of millions of dollars just based on Illinois users. So that's, on the other hand, something that if you are on the side of wanting tighter privacy protection and greater levers against big tech platforms, which again is not just people on the left, then that's a tool you really want to see in the legislation. So there are ways to bridge that gap, but those are the two sticking points. The thing about not wanting to deal with 50 state rules, companies love to say that, but there are scenarios where there's a race to the bottom rather than a race to the top. I mean, for a long time in telecom, that's what we saw, that AT&T and the other carriers had far more firepower at the state level than the state PUCs. And so they were actually able to be much more successful with things, in terms of avoiding regulation with activity at the state level than when it went to the FCC at the federal level. So, it's really a question of what the dynamics look like. I think if California has a set of rules that are much stricter than everyone else, then there's concern that there will be this effort to race to the top. But it's not just a unidimensional equation about how strict the rules are. The California Act is really focused on paying for data, and they had to do a fix in terms of what exactly that meant. There's a lot of pieces to privacy regulation that are not entirely there. The other thing about California is they've set up a regulatory agency. They're just standing it up now. And so it somewhat remains to be seen about exactly what the enforcement is going to be like there. So, yeah, I think there's running room. I think, enough people on different sides want to get a win here, including industry as well as both parties. It's sort of, not exactly the same, but sort of like what we had with the 96 Telecom Act, which would have passed as the 94 Telecom Act under the Democratic majority Congress, and then wound up passing under Republican majority Congress under Newt Gingrich, with Bill Clinton as president. That was going to happen because that constellation of interest was there, and that's what I see to some extent now.
So the other thing that I find fascinating about privacy is, unlike things using the space, which normally goes to the Commerce Committee, privacy, I believe, falls in the jurisdiction of the judiciary committees, where you have a different set of actors and a different set of interests. And so frankly, a different level of engagement with the relevant companies here. And so when we see how this is going to play out, it'll be very interesting to see if the personalities matter, and frankly, the small p politics, I mean, the real mundane parts of this may end up being extremely influential. You mentioned private cause of action. California does have one, but it's very modest. It allows for public interest organizations to bring these. It's not the kind of sweeping one you see in Illinois. And you may wonder if some of the industry may take a look at that and say, we could do a lot worse than California, because it's not the kind of GDPR general prohibitions on the use of data. You're right. It's about sale. It's about, if you've got data, to limit your ability to transfer it to other people. It doesn't have the same degree of restrictions on what you can do with it if they're directly your customer, and how much notice you have to give them, allow them to withdraw consent, allow them to erase data, correct it, all these different rights that could be actually much more intrusive than they would be if you saw California as the default regime nationally. So
yeah, absolutely. And then the other thing that's happening in the background is, we have the Schrems II decision. And so internationally, there is this negotiating process that's going to go on with Europe, where the safe harbor mechanism, privacy shield that was put into place to allow global data flows, is now needs to be replaced or fixed again. Europe in that negotiation cares more about surveillance, about U.S. protections against government intrusion for European citizens, but in general. And that's something where I suspect that the mood has changed somewhat. I mean, we're now 20 years past 9/11. and the environment that led to the Patriot Act and led to the surveillance that was revealed by Edward Snowden. Now we're in a world where we're focusing on COVID and we're focusing on things like climate change and so forth. So again, I don't know exactly where it's going to go, but I think even though these are issues that have been in the spotlight for a long time, the politics, big P, small p, domestic, international, they're all somewhat different. And we have a different kind of administration. We're seeing this already with Biden, where he's someone who built his career as a centrist, and here he is now. In the early days of his administration, passing what seemed like some very progressive legislation, massive spending bills, and so forth. And so we'll see how that plays out, but it seems clear that this is not your father's Joe Biden administration, and so that may trickle down to a lot of these other areas as well.
Well, but in all fairness, the first relief bill is enormously popular. I mean, it's like a 75% approval. So I wouldn't exactly say you're pushing far outside the centrist mold. The interesting question is the $3 billion infrastructure bill. That'll be interesting, and it'll be interesting to see if it ends up being about principle, or if it ends up being conventional political horse trading, where if you just, this, I always think back to what I think of some of the most brilliant legislative achievements I've seen were done by Ronald Reagan in the face of Democratic administrations, Democratic Congresses. And it wasn't about principle. He found little things to give to individual members to get them to support the bill and just cobble together a majority. And it was pretty amazing. It's the kind of legislative skill that Biden actually may have that we haven't seen in the White House in a long time. And so here's hoping. Just to clarify something, just so for people who don't know, you mentioned Schrems and Schrems 2. Just to back up, so the European privacy regime is called GDPR. It was enacted in 2016, and it went into effect in 2018. And they have a practice, or there's a mechanism in place where you can export normally you have to export your data only to other countries that comply with European privacy law. Unless you get a certification from this body to say that it may not fit the exact letter of European privacy law, but it's close enough and they're providing enough privacy will allow that to happen. Well, that was going on, and then the Snowden revelations happened, and in what we call Schrems 1, the European Court of Justice said, yes, we approved, the European Commission approved the US as a proper recipient of European data because their privacy is enough. But look at Snowden, it's very clear that the US government has access to all this information that they're not supposed to under European privacy law. They no longer comply. And so they struck down what was called the Privacy Safe Harbor. Well, they went back to the drawing board and they created a new thing called the Privacy Shield, which you just mentioned, to try to bring back the US under protection so European data can come to the US. And the European Court of Justice struck that down in Schrems 2. So strike 2, we have 2 rounds to this. And now we're trying to figure out in this world, what's going to happen with Europe in terms of, are we going to be able to get another regime that's adequate, that they'll deem adequate? Are all U.S. companies simply going to have to comply with GDPR? You look at the Facebooks and the Googles, that's simply what they've done. They actually have not, they're not that invested. It's really more the smaller companies at this point who really depend on those sorts of devices to be able to share European data back and forth. And so I think it's great for you to really flag this issue, because I think it is going to be really influential, and actually not even so much for the big tech, but sort of, if you will, mid tech and these other companies who are actually operating in, for whom the burden of complying with GDPR is actually much, much larger, because they don't have the overhead or the infrastructure in place that the Facebooks and the Googles do. Now, you mentioned Europe. Go ahead. No. Go ahead, please, Kevin.
No, I was just saying, I think I said this before, but I think the international dimension of all these issues is going to be a lot more central than it has been in the past. And that should be obvious, because it's a much more global world. But I think for a long time that, the sort of global privacy debate has been, Europe saying, we're better than the US. Now we're seeing some of the problems with the European system, and we're seeing people in the US say, okay, let's learn from what they did. Can we do something that is better, or at least makes more sense in our economy? It's a real serious effort to engage with these issues.
Well, since we're talking about international, you've also mentioned China. What do you think is going to happen with Biden in China? Because we had an administration that really was at odds with China. I don't, the early signs in the Biden administration is not back to kumbaya. I mean, it'll be really interesting to see what happens. Do you have any, I know this is something you track a little bit. Any thoughts about how the Biden administration will handle China, particularly in the tech side?
Oh, I track it a lot. So, I mean, so look, China, is going to be the biggest economy in the world. It's has a huge tech ecosystem, companies like Alibaba and Tencent and so forth domestically. It is very aggressively looking to be a dominant player in what it calls new infrastructure, but sort of next generation technologies, starting with AI, but including things like blockchain as well. It is responding to what happened in the Trump administration with the sanctions against Huawei and aggressive U.S. efforts to push back on some of China's attempts to steal intellectual property, to engage in global surveillance, and so forth. So, China has made it very clear that it is going to try and build up domestic capability in all these areas, so the U.S. cannot weaponize interdependence against it. And China wants to be the dominant technology player in the world. And I say that not as an attack on China, that's something inherently evil. China, is the biggest country in the world by population, has a extraordinary culture and history and everything. And just as the U.S. wants to be the one that shapes the future of the world, so does China. And I don't think we can ignore that anymore. Not that we have in recent years. The Biden administration, I think, has been fairly clear that the parts of the Trump administration policy that were about saying, we no longer are going to think that development will make China more democratic, that just inherently, if China opens up, that it's not going to be an authoritarian state. To the extent that we believe that, and I think it's something of a misnomer, the extent to which previous administrations were that naive. But we don't believe that anymore. And that's something the Trump administration was very clear about. And it's something that the Biden administration, I think, going back to the campaign, has been very clear that it's going to continue those efforts and frankly, ratchet them up. The Trump administration didn't care that much or place a high priority on human rights issues. It was all about trade. And the trade issues are very important, but the Biden administration does care a lot about human rights. So there was a fascinating meeting happened just a couple of days ago, the first high-level meeting between Anthony Blinken, the Secretary of State, and his Chinese counterpart, and Jake Sullivan, the National Security Advisor. The U.S. side sat down at this meeting in Anchorage and raised human rights issues in the Uyghur minority in Xinjiang, about what China's doing in Hong Kong and so forth. And the Chinese side responded with this 17-minute diatribe about, the U.S. shouldn't be lecturing anyone. We've got all of this discrimination and all of this corruption and so forth. And it was very frosty. It frankly was frostier than any high-level meeting that happened like that in the Trump administration. So this is going to be interesting because both countries need each other. We are tremendously enmeshed with China in technology. You look at the innovation that's happening there with things like TikTok and what they're doing with next generation e-commerce, and China needs the U.S. and not just needs the U.S. for markets and for some of its component technology, but they need access to the kind of innovation and development that happens here. So I think there is good faith in the Biden administration. This is not about beating up on China. This is trying to hold China to account. And trying to find ways to cooperate where we can, but it's going to be a challenge. It's going to be a huge challenge for, I think, the rest of my lifetime. China's not going away, and I don't think the U.S. is either.
I just want to make sure. Can you hear me still, Kevin?
Yeah.
Okay. I'm having some problems with my connection, but I'm dialed in through my phone as well. So what's fascinating, just so you know, you mentioned Huawei. This has been a whole new dimension that we had never seen before, which is in Huawei, for example, they are a leading provider globally of 5G wireless equipment. And in fact, everyone, if you talk in a lot of circles, if you go to Mobile World Congress, it's all about 5G. And there's been some allegations or concerns that maybe that Huawei provided equipment may have some vulnerabilities. And what we're discovering is when they went and studied it in Britain and the like, they found some truth to that. So here's a wonderful classic problem, which is there is credible reasons to believe that there's some security problems. At the same time, it can be completely overblown largely for trade reasons. And our ability to distinguish the two is extremely limited. And so it's going to be some interesting problems. And what I see is fascinating is in the most recent, in the stimulus project, in the stimulus that we saw, the COVID relief bill, there was actually money set aside for telephone companies to get their Huawei equipment out and to replace it with other equipment that didn't have that in there. The large telephone providers never put it in, but some of the smaller ones and the rural ones did. And so it was a big enough concern that it actually moved the needle on something like COVID relief. And there's a big, no, not big, but a non-trivial pot of money sitting there to try to work that out. And as I seem to recall, I think the Chinese recently put a protest out about U.S. equipment and limiting what they can do, saying, oh, we don't know what kind of security stuff has gotten in there, see Snowden. And so I think you're right. We're just at the beginning of what's going to be probably a pretty extended and contentious phase of our relationship with China. On the other hand, we have this rhetoric of the Trump administration getting tough with China. And I think we're seeing right now, maybe in certain areas, certainly on human rights, they weren't as tough with them as they might have been. So it'll be interesting to see how this unfolds, particularly as to go back to what I'm saying is what I said earlier, which is how it ties to the main priorities of the Biden administration, because they'll do that in their high-level meetings, but in the end, they've got to come to grips with it one way or the other about what's going to happen in terms of their overall priorities and how do they make it fit.
Yeah, the hope is that it leads to some rational processes. So, what they did in the UK, and I'm not close enough to it to pass judgment about their cybersecurity assessment, but they said, all right, let's have our experts look at this and let's figure out what are reasonable limits. So they distinguished between Huawei equipment in core networks versus Huawei equipment that was in more peripheral positions in smaller networks and so forth, where the security vulnerability risk, if it existed, was not as great. And actually created mechanisms for their best experts to try and assess this equipment. I think that's the kind of thing that we're going to have to do here and do more broadly. It's not quite the same, but we had a process 20 odd years ago dealing with encryption in the phone network, where the concern was that as networks went digital, that the bad guys would be able to encrypt, and it would be difficult for carriers to provide access, or even without encryption, just to provide access on the digital networks to law enforcement when there were lawful requests with a warrant. And so we had this process called CALEA, Communications Assistance to Law Enforcement Act, which actually provided a significant amount of government funding to allow those network upgrades. And again, there was coordination on where to draw the lines, not to open up for massive surveillance, but you have a situation where law enforcement gets a warrant, goes through the process, has reason to believe there's a crime being committed, that the technology doesn't unnecessarily get in the way. We had a bigger debate about encryption and clipper chips and so forth back in the Clinton administration. And eventually it worked out. This is a little bit different because you've got China as an adversarial state actor and others like Russia as adversarial state actors in the mix. But I think it's a matter of getting to the point where, again, you get the best technological experts together with industry, with policymakers, and say, all right, what are we trying to achieve here? What are the goals? Privacy is an important goal, but also preserving our U.S. capabilities about intelligence gathering overseas are important goals as well. And there'll be interesting spinoff effects. I mean, in 5G, one of the interesting effects that's come out from this is there's been a lot more interest in what's called ORAN, Open Radio Access Network, which is a set of standards that will allow non-proprietary gear to be used more by carriers in their 5G deployments. Basically, one reason that Huawei has been so successful is they've gotten into many networks by having cheaper, very good quality, but very cheap gear. And then when the carriers want to do the 5G upgrade, they're basically locked into Huawei because it's proprietary. And again, that's a classic business strategy People like me, have for a long time in telecom been arguing we need more mechanisms for open access. Now, people like Christopher have pushed back on the economics of modularity and so forth. But I think it'll be interesting to see, this new policy political dimension from industry pushing for more open access networks to deal with this potential for Huawei lock-in. Now we can't hear you, Christopher.
Can you hear me now?
Yep.
All right. So one of the interesting things I would say is, independent of the lock-in to the economic side, we were talking about security. Open networks and security is an area I think the FCC hasn't fully come to grips with. Because, if you open up all the standards and all of this, it's open for everybody and for any purpose. And one of the things that I think has been flying under the radar is really understanding, how do you secure an open network? And how do you design that? And always have the classic security problem that, defense is 360 degrees around. You have to stop everything. The attacker only needs one little vulnerability, and then they can come in. And it's always been a problem. So it will be interesting to see, as part of this debate, there's an economic one that you and I have engaged in. But in the world of China, where we're worried about these sorts of things, are there other issues that are going to emerge that traditionally, frankly, have not been much part of the discourse in the telecom space, which are becoming much more? So just as an example of this, one of the things that was proposed during the Trump administration is a government-created 5G network. And for a lot of people, I think on both sides of the aisle, that sounds sanity. Why would we spend billions of dollars at a time where money's at a premium? We have a lot of things we need to do to build that, when basic 5G networks are something we have great confidence the private companies will do. Well, that push was coming out of the Defense Department, and they were worried about security. And there's a dimension, a policy dimension that's increasingly showing up in these debates that really weren't part of it in previous administrations, that I think may stick around in an important way. So I don't know if you have any thoughts, but go ahead.
Yeah, absolutely. Well, so to your very good point about security of open networks, I've got one word for you: blockchain. And maybe we can talk about that some, but but even if we don't, I think that there's a lot of hype about blockchain and cryptocurrencies, and has been for a long time. But they solve a fundamental problem. And the fundamental problem is about trust. I wrote a whole book about blockchain and trust. And when there is a gap in trust, and this is a very good example, where if you have proprietary closed control, well, then you've got to trust an actor. Maybe Huawei's network is very secure, but you got to trust Huawei. But then if you have an open network, then you have these vulnerabilities. Fundamentally, blockchain is a technological approach, the family of technologies that allow decentralized and open networks to also be trustworthy. And it's not a panacea, it's not a magic bullet. And again, there's lots of different variants of it. But for a long time, I felt in spectrum policy that we would see more movement to spectrum sharing, just because we have to. And actually, the Defense Department is actually one of the entities that's been coming more around to this position, because they got to deal with the battlefield where there's not a lot of spectrum that's just out there that they can get access to, new virgin spectrum. So we're seeing a lot of movement toward shared spectrum just out of necessity, and then the technology has to make that feasible. I think we're going to see the same thing with blockchain type technologies, that just, this is the approach, using these cryptographic techniques that is going to serve the need that is increasingly going to be prevalent.
So I think it's a perfect time to talk about blockchain and security. So let me ask you what I think is the big question about blockchain and security, which is, for those of you who don't know, blockchain is a distributed ledger where there is no one actor that controls the information. It keeps a record of something arbitrarily. It can be just about anything, and it distributes it to a lot of different locations. And basically, whatever the majority of those distributed locations thinks is the proper record. Let's say you're trying to keep an ownership record or an identification of who's done what. Let's take it easy, an ownership record, thinking of Bitcoin specifically. Basically, if you look at that and you look at the distributed ledgers and you see what the majority thinks, that's who they say owned it. And there can be occasional deviations, but they aren't bad. There's a classic problem with this, which is called the 51% attack, which is if you can fool 51% of these distributed ledgers to think that that piece of Bitcoin belongs to me instead of to Kevin, I can take it if by basically being fast enough and corrupt enough to get to hack enough of the ledgers. And we saw what we call the hard fork in some cryptocurrencies where they realized, yes, there was a successful 51% attack. We're going to roll back the ledger to a previous state where it was more accurate, and we're going to cut off that other fork and how it's going. And that vulnerability is irreducible. You can't get rid of it. I mean, it's inherent in the nature of blockchain. Am I right about that? And if so, how do we deal with it? It's better because it's distributed, but it's got some ways that it can be, that is some vulnerability still, no matter what. How do we balance this, Kevin?
Yeah, it's inherent. The 51% attack is inherent in a class of cryptographic networks, Byzantine, what are called Byzantine fault-tolerant networks, of which the Bitcoin architecture, what's called proof of work, is one. But as I said, it's a family of technologies. So there are various trade-offs that can be made. Bitcoin is about as decentralized as possible. There's no entity that can decide on governance decisions for Bitcoin. It's one reason that Bitcoin network, even though the price of Bitcoin has gone up, the people are willing to pay for it, is still incredibly slow and limited in functionality compared to some other cryptocurrency networks, because it requires those 51% of the mining nodes to agree on any kind of change, and they haven't. So yes, as I said, it's not a magic bullet. There are fundamental limitations, but Bitcoin is not the only possible solution. It's a solution that is optimized for creating a currency, creating money, and doing so in the most decentralized way possible. There are huge negative trade-offs that leads to. One of them is the incredible energy consumption of the mining. Another is the fact that the mining, those validation nodes actually become consolidated, mostly in places like China, it turns out. And so there is a tremendous amount of experimentation going on with a variety of different distributed ledger approaches. Some of them don't have quite that same limitation of the 51% concern, but they trade that off for more centralization. There's more trust you have to make, in certain kinds of actors. And if we're talking about trusting, say, the U.S. government, there are some people for whom that's a bug, that they will never accept that. But there are many people for whom, that's fine, and that's normal. That's what we do with money and with so many other things now. So if the only limitation is you've got to trust that the U.S. government is not a rogue entity, then maybe we're okay. So the point is, you're absolutely right. There are limitations. There are trade-offs. But what we're seeing is lots of innovation in coming up with solutions. It's not just the people speculating in investing in Bitcoin. There are corporate consortia doing blockchain for supply chain. There are countries using blockchain and blockchain-like technologies for what are called central bank digital currencies. And we're still fairly early, but again, the technical research, the cryptographic research is advancing very fast, and it's I think there are no gotchas here where there's something that's unsolvable. It's just a matter of, again, understanding what benefits we want to get and what we're willing to give up for it.
It's funny to me you use the word rogue nation. To me, it's relative. A lot of my friends who are in other countries, they said, yeah, we realize that, for example, giving cryptocurrency to the U.S. isn't the most secure thing, but it's still more secure than what we have here in our country. And so it's always a second best question. So it can be there's some interesting questions and complexities. So another thing that you talked about, areas of bipartisan support, and you mentioned earlier about the regulation of big tech. There does seem to be a good deal of bipartisan support to do something. Do you expect something to happen in terms of, well, there's a bunch of antitrust cases that are moving through, but as you and I both know, I think the trials on those are scheduled for 2023 at the earliest. Not that that's for a matter of this size and this importance, maybe that's appropriate, but the antitrust is not well known to be a fast-moving legal process. They're large, document-intensive, frankly, company-killing types of litigation. And so that's one issue. We have the House Cicilline report came down in November as a member of the last Congress. So some people are very optimistic about legislative reform. There's a lot of, if you will, smoke, but not a lot of fire yet. And I was wondering if you wanted to make any handicap predictions about what you think might happen or not in terms of the regulation of big tech, because there is, it is shocking to me how in just 5 years, big tech has gone from being the epitome, the model of everything that was good in American commerce and industry to being standing in front of Congress doing what I think of as the big tobacco perp walk with all the CEOs having to swear themselves in. It's a remarkable change in just a very short amount of time. And I'd be interested to hear your thoughts on what you think. How do you think this might play out in the Biden administration?
So I would bet against any serious legislation because here there's a consensus that something needs to be done, and everyone agrees. Let's go tar and feather the CEOs of the big tech companies and keep hauling them up to the hill to yell at them about how bad they are, and to point out all of the privacy abuses and so forth. But then you get down to what should we do? Other than antitrust, there's just wide disagreement, and we see this on Section 230, which was the provision that was put in the '96 Telecom Act that grants online services immunity from actions by their customers, as well as immunity for their content moderation decisions for the most part, where everyone agrees that something should be done. But they have diametrically opposed views. The Democrats want companies to moderate more. They're concerned about harassment and hate speech and misinformation. And the Republicans want them to moderate less. They're concerned about deplatforming, of Donald Trump and other conservative figures and their perception that there's an anti-conservative bias on those platforms. And so that just can't be reconciled. President Biden during the campaign said he believes that Section 230 should be repealed. But there was never anything really beyond that, and the people in the campaign and in the administration, have not been particularly eager to flesh out what that means and what the administration is going to do. It's something that I think there will be debate and there will be some work around the margins. There's some serious bills that have been proposed on Section 230. We could see something as part of a kind of larger agreement around some other issues around maybe these privacy issues or so forth. But I suspect that'll be at the margins. And so, yeah, I agree with you. Antitrust is slow, but antitrust is also in some ways more clear. And there can be disagreements about, what the right outcome is, but, there are market power tests and there are remedies that have been, applied and ways to think about what the path forward might look like. There are cases that have already been filed. Very clearly, having Tim Wu, who's been one of the leading advocates of stronger antitrust enforcement against big tech companies in a position in the National Economic Council and the White House is clearly a signal that that's something that will be happening in this administration. I suspect that's going to be the center of gravity. And yeah, you're right, it takes a long time, but AT&T took forever, and we can have debates about whether that was how badly that process went. But in the history books, it is written there was an antitrust case and there was a consent decree against AT&T, and that was a massive turning point in all of global telecom. The little twists and turns back and forth, which you and I know a whole lot about, most people are totally unaware of. So I think whatever this comes out, I think through the longer lens of history, that's probably what we will see as the major focal point.
So what's fascinating to me is just to put my own 2 bits in, I actually testified at the House hearing where the Cicilline report was supposed to be released. And it actually was on that Thursday. It wasn't released because they were hoping to get bipartisan support for it, and they failed. And in fact, what most people don't notice is that it's actually not a committee report. It's a staff report that the committee didn't actually adopt. And so this is, it's an important document, but to be clear about what level of endorsement it received, it is not even a majority report. It's a staff report written by the majority staff. And my primary quibble with it, even to me, giving it the biggest benefit of the doubt, the basic move they make is they had testimony that identified purportedly problematic behavior by Google, Amazon, Facebook, and Apple. They generalized from that to say, okay, so there is a problem with digital platforms, and therefore we need to change all these things about antitrust law in general. And to me, that's two enormous non sequiturs. So one is, just because you have a problem with 4 companies who are involved in search and social media and e-commerce and cloud and devices, to suggest that you have this problem with Google, supposedly, or Amazon, Facebook, and the like, to then say, oh, to put them all in the same bucket of digital platforms, or as a problematic phenomenon, to me ignores the fact that they're very different businesses, and it's skipping a lot of steps. Okay, you have a specific harm found for one company, so you want to remediate that, you do something specific. Instead, they actually painted them all with a broad brush and sort of condemned them. But then the bigger problem is, even if you have a problem with digital platforms, why would you change antitrust presumptions that are going to affect, healthcare and manufacturing and all these other old economy industries? And I just didn't find their argument terribly satisfying. The other reaction I had is and I've heard this, we've brought this up in some discussions that we've been in, there's a group we call Cyber Lunch, which we both belong to. And I remember after the DOJ dropped its case against Google, a lot of us were pretty underwhelmed. There wasn't really a new theory. There were no new allegations that went beyond the previous 2013 investigation of the FTC or what the EU did. And in fact, it was sort of, it was a reaction of, is that all you got? And in fact, the other really strange things about it is, usually when there's a major investigation, the staff talks to a lot of industry actors, customers, competitors, and information about those interviews leaks. There wasn't a lot of that, and it seems, that people have the suspicion that it was rushed out the door towards the end of an administration because they'd started something but didn't really have something that was ready for prime time, but needed to get their marker down before that they left office. And that, in fact, we didn't see the kinds of concrete allegations there that would say that this is a fairly well-developed case that is ready to move forward, which isn't to say it might not become one, but I think that, my takeaway from that is that case still got a ways to go before it's going to really gel into something that might be the type of action that you're discussing.
Another thing to keep in mind is companies can change. Microsoft is a very different company today than it was before the antitrust trial. And that's partly the antitrust trial. It's partly coming out of that. They had the period where Steve Ballmer was CEO, and they went sideways for 10 years until Satya Nadella came in and said, we have a really great business without using the traditional very exclusionary embrace and extend model of Windows. That we can actually succeed really well in this kind of services-based world. Google is a different company in the other direction. I met Larry and Sergey right after they left Stanford. I wrote one of the first articles about Google, and I actually laughed. Larry Page, I said, "What is your goal?" He said, "Our goal is to become a public company someday." And I was like, "Come on, you got some really cool technology." But back then, "Don't be evil" really meant something. It wasn't just a funny slogan. They were, all the search engines were clogged with all of these ads and so forth, and they weren't. Google has evolved into something different, which is probably inevitable, to the scale that they're at now. But that can change again. We're seeing really interesting dynamics right now between Apple and Facebook, where Apple is aggressively promoting its privacy bona fides and implementing them because it's in their economic interest. They make hardware, they're not an advertising business. But now Facebook is pushing back against Apple. And so, it doesn't always, again, it goes back to my point about race to the top and race to the bottom. It doesn't always work out for the best. But I think the smart companies of these big platforms, they can see which way the wind is blowing. They can also see what's happening in China, and the Chinese companies are not going to be predominantly in the Chinese market forever. And they can always differentiate themselves against the Chinese companies, given the different government environment in the two places. And so you could see significant change that's not necessarily legally mandated as such. Again, it will take time and so forth. but that's a consequence of all these other dynamics.
So I also wanted to clarify for people who aren't familiar with it, something else you mentioned. You mentioned a provision called Section 230. And Section 230 is a part of the Communications Act that gives immunity to actors who are intermediaries. They just they transmit other people's content or just host people's content. And in a way, this is very similar to what, say, a bookstore is. If a bookstore, you can't sue it for defamation because otherwise they have a rule that if you don't know that there's a problem, you can just say, look, we're just here to sell books. Otherwise, they have to go through and read every book before they put it on the shelves to make sure that they're not subject to liability. And Section 230 enacted something like that. It actually included something called the Good Samaritan provision that allowed people who host content not just to be pass-throughs, but to even exercise just a little bit of discretion over really offensive stuff. And there's a statutory term like offensive, lascivious, and I can't even remember, but it's a long thing that goes through. And this has been called, I think, the most important section of the internet, like the 13 words that changed the internet. And the idea was it was essential to free speech, that by freeing internet intermediaries from liability, they no longer felt that they had to do what I just described about bookstores, look at all the content and make sure that it doesn't offend, and that it became important if we're going to see the kind of speech environment that we generally associate with the internet. Now, I'll put my cards on the table here, which is I was a 230 skeptic after a while. I mean, this was for, they're young companies. Well, these aren't young companies anymore. They're perfectly well-established and able to do it. And recently, about 2 years ago, they passed a law called SESTA and FOSTA. And I don't remember what they stand for, but it's basically about the sex trade. And they said, that immunity you have for hosting other people's content, that immunity does not apply to advertisements for prostitution. And so think about this from a political standpoint. Who's opposed to something that's trying to stop prostitution? What's striking is Craigslist, Facebook, all these places didn't actually vet their the content they hosted to see if it was advertising for prostitution. Craigslist took down its entire personal section because rather than to have to sift through the wheat from the chaff to figure out what's proper and improper, they said, hey, this is too risky. We're going to cut out this entire category of speech altogether. And frankly, I have to admit, I was a bit surprised. I didn't think that that concern was as serious as it was. But I think that brought it home. So now we take it to the modern day, which is under free speech doctrine, the First Amendment prevents the government from taking actions that edit speech. But the government doesn't limit what private actors do. And we see in this world where Facebook started flagging posts, during the campaign, during actually the post-election as we were going up to it, and we see actors like Twitter deplatforming what was the sitting president of the United States, and they had an understandable policy. They said, we're not even going to we have a deplatforming policy, but we're not going to even exercise that fully against heads of state because they're so worried about that. And I'm curious, this, to me, I think you said it very well before. Usually in a free speech question, there's a safe way you can give where you can jump, which is, if all else fails, you just you avoid the regulation of being too restrictive in one way, and you can at least fall back to a notion of, okay, I'm on the side of the angels by not exercising any editorial control. What really strikes me now is a lot of these companies are kind of damned if they do and damned if they don't. Is that if they exercise, as you point out, too much control, they'll get criticized for being private censors. If they exercise too little control, they'll be criticized. And they're facing basically a public where the views of what that ideal point is all over the map. So they're guaranteed, no matter what they do, to be criticized for what they do. And I have to admit, I think that they're in a really tough position. But the interesting question for me is from a law standpoint, is this consensus of everyone being unhappy going to lead to something, or is it just going to be more complaining? And I gather you suggested maybe it's just going to be more complaining because you don't see major reform to this particular statute happening during the upcoming years. So I don't.
I think there are law professors like Danielle Citron and Marianne Franks who are arguing for who consulted on some of these bills that have been proposed, who are arguing for narrowing the scope of Section 230 to deal with some of the concerns about harassment and revenge porn and so forth. And who have, they've written law review articles on this. There's serious efforts taking into account the issue of what happened with Sesta Fosta, which was really too broad. Yeah, I just don't see the political constellation to make those kind of changes, and those don't deal at all with the concerns about deplatforming and so forth, that are out there. Yeah, look, I mean, again, everyone wants to beat up on big tech, but there's not any easy way out of this. It's fundamentally a problem of scale. And the question becomes, again, what's the set of incentives and what kind of bets do companies want to make? It's not exactly the same issue, but we're seeing interesting developments. To go back to the privacy front, it was a similar kind of issue with companies scraping data on the web, where there's not a Section 230, and under intellectual property and other kinds of theories. Something called the Computer Fraud and Abuse Act, where arguably if I scrape data from your website, that's criminal hacking that I can be prosecuted for. Many companies have resisted using that kind of data access, but some have been bold. One that was bold was one called Clearview AI that built a facial recognition engine on scraping 3 billion people's faces that were available on social media. And all the platforms, Google, Facebook, Twitter, everyone sent them very sternly worded cease and desist letters. This violates our terms of service. Stop forthwith. Then Clearview AI said, nope, we're going to hire Floyd Abrams, a famous First Amendment lawyer. We'll take it all the way up to the Supreme Court. Now, I have big problems with Clearview AI's business, but they're making a decision. They, and with the support of their investors, presumably, that they think that they can survive in the gray area of the law. I think the Sesta Fosta's example, is a situation where companies like Craigslist didn't want to, because it's, the benefits for them of hosting sex trafficking ads is not that significant relative to the cost of taking them down. But I think there's more room for give here than we think, perhaps.
So what's fascinating to me is there's a similar fight happening about scraping in Australia that's very high profile right now, which is the government is unhappy with the Facebook and Google scraping information for ads or for search results for snippets, and has threatened them with legislation to make that more, and to penalize them for that. And at that point, we saw this happen in Spain with copyright. Google said, okay, fine, we just won't do this anymore. And they got out of the business. And Facebook did too. Google has now cut a deal back with them to try to come back. But the two reactions I have, one is, isn't this Bing's golden moment? If in a world where we're trying to get more competition out of them, and I'm told through someone, Microsoft is actually seeing it that way, which is if Google is taking unduly restrictive policies that aren't good for consumers, the obvious thing is what we really want is a more competitive search market. Instead of making them open it up, if you have another company that's willing to do it, there's a much more complex dynamic, I think, that's flying below the radar. The other point that I love that's often overlooked is that the primary advocate for the position against Facebook and Google, and the primary beneficiary of this regulatory move, is Rupert Murdoch, who is, of course, that small garage innovator who we have to protect against the predations of big companies. No, Rupert Murdoch is usually on the receiving ends of complaints like this, and it's fascinating to me. If you look in Europe, some of the main advocates of the competition law cases against the big platforms are traditional media. And so it's an interesting, the idea of sort of consumers against these big companies and all that is belying what you and I both have seen often in these fights. It's often two different types of big companies butting heads because they have different interests at stake. So, what I find is I think there's a much broader set of dynamics that's overlooked, both in terms of competitive responses, but also the underlying political economy about these fights over scraping.
Yeah, it goes back to where we started, that, in some ways we're talking about the same issues that people in tech and communications policy have been talking about for decades. But in some ways, it's everything is so different. So I wrote that digital tornado paper at the FCC, and actually I wrote it in 1996 or 1995, but then I had to put it aside to work on implementing the 96 Telecom Act, came out in 1997. There were 50 million people on the entire internet. The biggest internet companies were companies like AOL and Netscape that don't even exist anymore. Now here we are with, north of 5 billion people on the internet. And it's something like 7 of the 10 most valuable companies in the world are digital platforms. And in fact, so every aspect of life. So that's just different. And therefore it feeds into all kinds of issues about political power, economic power, and so forth. But at the core, we're still dealing with, the same sets of questions. And I do think we can make headway on them. And, there will be different responses in different countries. I think one big thing that is happening is we have had this era of a kind of global internet. And it's balkanizing. I mean, partly because of what's happening in China, which for a long time has excluded the US-based companies, but now the rest of the world is pushing back. Part of what's happening in Europe, where they are actually in favor of this notion of digital sovereignty. They want data to be localized in Europe for privacy reasons and concerns about the US, which I think is actually counterproductive. It again pushes away from this ubiquitous interconnected platform. But we are no longer going to be in the unified global internet environment. It's a question of what replaces it. And again, these tensions have been there for a long time. I've written about them, you've written about them in different contexts over 2 decades. But now they're going to play out on the biggest possible stage.
So what's fascinating is I do think on some level it is similar to the past issues, but there are things that I think are either different or having new importance. And some of them I think are the biggest global stuff, and some of it's the smallest local, tiny regulatory stuff. So to give you 2 examples, you said earlier China is flexing its muscles on the international stage. That is absolutely correct. They have a new initiative called New IP, or IP 2030 sometimes. They're trying, and they're talking about replacing the internet protocol, this one unifying phenomenon that made the internet work, and also replacing what we call DNS, this thing that makes the addresses all uniform and the names all uniform and allows us to work on things. And it's being pushed by the ITU, which is currently headed by a Chinese representative. And so it's not an accident. This is the last of a series of things where they've been trying to assert more influence over internet policy. They're trying to move it from what we call multi-stakeholder organizations, where user groups and technical community and companies have voting roles, as opposed, and they like to shift it back to a UN organization where only governments vote, only governments speak, and only governments set agendas. And it would be a very, very different move, but it's one that they're pushing very, very hard. And it's something that I'm starting a paper to study this coming summer. On a very micro level, there's a very mundane issue around building new networks, which is we're seeing with 5G and the people having to go very local, they have to put new little radio broadcasters on top of different locations on a much smaller scale. They're going to operate on much smaller sizes than ever before, so they have to put up a lot of them. And there's this really tiny thing from 1978 that was really updated in 1996 called the Pole Attachments Act, which, when I talk to my friends who are active in the business, this is a big deal. Can they get access on this, to get local governments and these local negotiations with electric power utilities and telephone companies to get access, and municipalities to get access to poles? And not only that, usually we were just hanging wires on poles, and those don't weigh very much and they don't take up a lot of space. Now we're putting wireless equipment on there, and the poles are now getting taller, and the equipment you're putting on is getting heavier. And so now we're having to replace poles. And the question then is, we had a fully amortized, built-out network floor. It was easy. Now, who's going to pay for that new pole? Is it the first person on there bears all the costs to shed all the risk off the utility, or do they have to be aware that someone else is going to come along? This is a big fight, and it's really nitty-gritty, it's mundane and micro, but it actually is going to have a huge influence on how much access to the internet people who don't, all the citizens in the US have, and it could have a direct impact on the digital divide as well. So we are getting close to the end of our time. We would love to have any questions. I would encourage you to use the Q&A function if anyone has one. We do have one question submitted already, and it's from Gavin. It says, Pre-COVID, it was usually quite taboo to record a business meeting or lecture. Now they're almost always recorded, or participants are using screen recording software to record sensitive information on Zoom. How do you anticipate the law will adapt to this new issue? Also, please delve into the AI ethics if there is time. Well, Kevin, I know you'd love to delve into the AI ethics.
Yeah. I can just say I'm in favor of it, we can get into it more if there's a more specific question. So it's a good point. I mean, the mechanics of this are legally fairly straightforward, right? It just terms of service and click wraps and so forth. But yeah, I think that in general, COVID and in this kind of virtual year that we've had has laid bare some really serious privacy issues where we're starting again to have conversations about them, about what's appropriate and what's not. We had the debate at or not really debate, but it had the issue come up at Wharton where we have had for at least 10 or 15 years cameras in every one of our classrooms, but they're turned off by default. Faculty members can say this camera must be literally physically turned around. So even if it gets turned on, it can get turned on remotely. It just shows the wall because I want to have an environment of open dialogue with my students and I don't want any possibility of recording or third-party access. When we flash cut to online last spring, the administration said, I think correctly, you have no choice. We're going to record every one of your classes because you will have remote students and they need to have access to this. And I think that made sense, but it doesn't really answer the question of, well, how do we deal with privacy issues and access issues and so forth? Just one really small example that now this has been flagged. Similar issues about COVID contact tracing, about privacy with vaccine passports and so forth. So I think privacy has already been a huge issue. There's been a lot of debate on, but I think we're opening up a new front beyond the ones about big data platforms and targeted advertising and so forth. I think we're going to see a lot more discussion. It's not yet at the point of regulation, but of debate about where to draw the lines, and I think that leading to people thinking about what might be some appropriate rules in different circumstances. Because it's certainly something that a lot of people care about, and maybe they didn't think about, but now all of a sudden you can't avoid it.
So I love your point about circumstances. To me, sometimes people talk about privacy protections as if they're absolute, fixed, and unchanging. To me, it is contextual. I did some work last summer looking at waivers for COVID of the privacy rules. And people understand that, in fact, there's an optimal amount of privacy, and it's going to change based on the nature of the threat you're facing. If the public health need is sufficiently large, and we all know this has been unlike anything any of us have seen in our lifetimes. This is transformative. And so if that's the case, what you found is all these jurisdictions waiving the privacy rules, and it's an interesting problem. California doesn't have a provision for doing that. And so it's been one of these things, but GDPR Europe said, look, we got to share this information. You got to share it internationally because we knew that research is the only way on a vaccine was our only way out of it in the end. And so you saw some of this post 9/11, and you could see I see it in Israel, where their notion of the threat environment they're in gives them a different sensibility about what appropriate levels of privacy are. And so I think that people are more tolerant now of this because of the needs, but also the realities. We know that there's students who are facing challenges who need their classes recorded. There's family situations, pressures, it goes so many myriad different ways. And I think we're all becoming aware of that in this environment, for this justification, for a certain amount of time, maybe we have the Wharton change where we start filming everything. And just like, for example, a change in my lifetime, we now record all classes on religious holidays and over a broad range of faiths because we understand there's certain realities to this. And that's probably a sensibility we didn't have always before. And I could see any one of a number of things that if there were some sort of emergency that would make it very difficult for students to attend a class for some reason, we'd probably record that too. And so we have this more contextual sense of it that makes it okay to record things because, and I hope Cheryl that's true, because it's exactly what we're doing right now is recording this. We have another question, which we'll hope, maybe the last one we get in, but we'll give it a shot. One suggestion I have about confronting the Section 230 issue is to remove technologically anonymity. Is it possible to remove technological anonymity from the internet?
No. So the issue is what kind of identification does the platform require? And so if you have a service that doesn't collect any personal information, then, or that, allows people to use cryptographic methods to obscure their identity, then that's not something that Section 230 or no Section 230 would change. But one question, and one of the concerns that people have about removing Section 230 protection, it's sort of similar to what Professor Yu was talking about with Sesta Fosta, is that if platforms can be sued for comments by anonymous users, one of their responses may be to not allow anonymous users. And to say, we've got to collect your identity, you've got to use your real name, and if we get a request to reveal your name, then we will do it. So that's not technologically or technically making someone not anonymous. It's changing the business structure of the internet in a way that would push against anonymity. But again, I think that's one reason why there's a great deal of concern. Anonymity is a two-edged sword. It's a big issue that we have a lot with cryptocurrencies, and blockchain as well. I think that there, as with the privacy issues, there's some healthy debate about where it's beneficial and where it's not. So, for example, China is creating this central bank digital currency where they are saying your transactions will be completely anonymous, like cash, with the merchant, with the counterparty. Technically, cryptographically, there will not be any way for them to know who you are, which is absolutely not the case with credit cards and all kinds of digital payments. On the other hand, if the People's Bank of China or a Chinese government authority, they say subject to legal process, wants to know who you are to go after you for money laundering or something, then they can get access to who you are. And again, that's not necessarily the accommodation that we are going to make here in the US, nor should it be. But that's an example where I think there are lots of technological capabilities that we're going to start to explore. And I think that can be a healthy process, but again, it's got to be done out in the open, in ways that get people to think about what are the pros and cons.
So what's fascinating to me is starting talking about China specifically. You've hit on an example in privacy where the difference in ideology in underlying their legal systems has tremendous import. So for example, you are not, when I go there, they say, do not talk about judicial independence in China. Why? Because there is no such thing. Everything's subsidiary to the party. And so they're all just organs of the party. So the notion, nothing's independent of the party. So you don't want that. And part of this also goes to the liberal tradition in the US about privacy. There's some part of yourself that's supposed to be beyond the government's control. In that system, they don't believe that. And that, in fact, things such as the use of personal information is just another means of promoting social welfare. And that they have a very different sense of what is involved, what implicates privacy, and what the proper role of privacy is. Now, the other thing to talk about anonymity, just to break this down a little bit farther than into two parts, there's two types of access here. One is the networks and people who pass it through, and there's other websites that host content. The people that pass them through are kind of interesting because, in general, you can lie. There's two ways you're not anonymous. You have a destination address, and you have a return address, like who sent it. The funny thing is you can lie about the return address if you don't need to get anything back, but you do need to be truthful about where it's going. But if there's any interaction going back and forth, you can usually find out where they are. There are anonymizing functions such as things called Tor, which allow you to do that. But I was talking to one of my students, an engineering student in a class yesterday. Apparently, there's some rumors that the government has found a way to hack Tor. And the question is, does the government have an ethical obligation to preserve the anonymous nature of the internet by disclosing it to people? Or do they? Is it okay for them to hang on to it? I understand the philosophical question. I'll tell you right now, there's no way they're giving up that hack. And they'll say, look, we're the government, trust us, the way Kevin was sort of saying before. If that's going to happen that way, that makes sense. The host on the website is not as anonymous as people think. So the notorious one, there was a former Penn Law student created something called AutoAdmit, and people depended on their supposed anonymity. Guess what? If you get a court order telling you to disclose who those people are, everyone does that. And so the idea of those websites relying on the inherent anonymity of the internet, there's no such thing, because there's got to be some relationship and some identity back behind it.
Yeah, and of course, anonymity is wonderful, but anonymity is also why we have so many robocalls. Okay, so
yep.
Again, it's like what we were saying with privacy. It is contextual, and I'm not wildly optimistic in the near term that we'll get beyond the politics and so forth for all the discussions about these issues to be as substantive and as thoughtful as the ones that we're having. But I think we'll see more of that because again, it's companies are going to need to make decisions and regulators are going to need to make decisions, and they're going to have to surface these issues. And it's a lot easier to decide more narrowly than to have to come up with some big, okay, anonymity, yes or no on the internet. So yeah, I think going forward, we're going to see more sophistication of those discussions.
Well, we didn't get to AI ethics to give it its due. Kevin, we're just going to have to schedule another one of these talks and have another conversation sometime in the future. But in the meantime, thank you for sharing with us your perspective on all the things we did manage to talk about. I think we got to almost everything you put on our desk, but if not, we'll just have to take it up another time.
No, my pleasure. Thanks a lot for having me. If anyone wants to follow me, Twitter @Kwerb, KWERB. Again, thanks so much, Christopher, for the opportunity.
Thank you. And as we said, we have a number of events coming up, both which I mentioned at the beginning of the broadcast or of this Zoom webinar. Please join us. Our next one is Thursday on the PIPG Symposium on the American Invents Act. And all that's available on CTIC's website. We hope to see you at an event sometime in the near future.